The time is 8:41 a.m. and I now call this meeting to order, the Oregon Board of Physical Public Session for the purpose public session. Michelle, could you call roll?
Yes, ma'am. Timothy? Here. Aaron? Here. Mariah?
Here.
Sandra?
Here.
Boku?
Here.
Susan?
Here.
Erica?
Here.
Dwight?
Here.
For staff, Michelle, present. Sherry?
Here.
Gayla? Here. Sarah?
Here.
Joanna?
Here.
For the record, we do have members of the public present. And a ghost. Next slide.
Erin, could you please read this for us?
Yes, the statutory purpose is to protect the public health, safety, and welfare for all Oregonians by maintaining standards for quality care, professional skill, and competence through the effective regulation of the practice of physical therapy.
Next slide. First agenda item today is the consent agenda item. The consent agenda is a packet of materials that are sent out to the board members for review prior to the meeting. For those of you attending or accessing the recording after the meeting packet is also posted on the board's website, so you can follow along with a copy of these slides and these materials. The first item in the consent agenda is the meeting minutes draft from the March meetings for review. The item also includes the ratification report of licensing actions since the last board meeting, and then the director's report and the financials for the 2 months, March and April, since the last meeting that are fully audited. A couple of things that I wanted to highlight. Sarah, if you could move forward through the documents to the director's report. The data that you are seeing in the director's report, and I'll have Sarah zoom in here on some things in just a second. What I do want to highlight is that this is the last view that we get before the end of the fiscal year, which is June 30. The next meeting is July 16th. So we're almost with a full biennium of data. So zooming into the financials, you can see that our run rate is probably going to end up roughly with what we're seeing here. We do have some expenses that come in toward the end of the biennium from some of the project work that we've been doing, but it's not going to make a significant variance from what we have here. And I do believe that we're going to hold right at about that 2% above the budgeted income for the year. And Sarah, if you can actually zoom in on to what is the next page for the licensing counts. And here, because we are close to the end of the biennium, you are seeing a forecast in the June 30, which would be inclusive of both May and June numbers. In the last, since the last board meeting, we ended up at about 1.2% growth for March and April. I did leave the forecast at about 1.3% growth. So that is the license count that I anticipate will be at roughly, might be a little closer to 1%, but we seem to be running at about that rate of licensure. If you go down that same page, in context then, what you see here with the graph on the other side, the orange represents individuals that are practicing in Oregon under a compact privilege. And you can see that we continue to hold steady at about 8% for PT, 9% for PTA. This number does change because unlike our renewal cycle, which is once every 2 years, compact privilege expiration dates are tied to the expiration date of the home state. And so there's a lot more volatility in what that number is over time. But in general, the percentage of the total population that we have authorized to practice in Oregon is about that 9%. The at the top of on the next slide, at the top of that page, if you could zoom into the summary table. Yep. And one of the things you can see here, the number, it's a little hard to read, but the biennium total, which is 1313, which was for the 21-23 biennium total. And then the total that we have so far through 4/30, that number is 893. So when we look at total applications that are submitted within the biennium, you can see that those applications are down. Now, some of that is because it's been offset into compact privilege purchases. And so that's part of why you have the differential. Income is still up, even though total applications are down. To get kind of another view, Sarah, if you go over to the other page for the privilege holders, this is new information that we had for the first time in the March meeting. We have 2 graphs that are based on the distribution of compact states where privilege holders who purchase a compact privilege into Oregon, where they're coming from. What you can see here is that our 2 biggest source states, if you will, are unsurprisingly Washington State, but then also Texas. We think that has something to do with just population dynamics and that a lot of travelers tend to be based in Texas, but then travel for the short-term contracts. But the rest of the table at the bottom of that page just goes through by state. Then on the next page, the next slide, you see a similar graph, but this one is where do Oregon licensees purchase privileges into other states? You see similar patterns, but you can also see a pretty significant when Washington license holders buying purchase compact privileges into Oregon, it was 96. You can see that Oregon license holders, 236 purchases into Washington State. That again is also probably population dynamics, folks in the Portland area who are also serving the Vancouver, Washington area. But some very interesting trends that as we continue to accumulate this information, I think could be helpful to understand where folks are coming from and where they're going as a benefit of the compact. On the other side, Sarah, if you could kind of zoom into the total, the graph at the bottom of the page. And what you can see here is if we, where the other tables have been focused on the active counts that we have right now, this data looks at total number of purchases over time, initial or renewal. And you can see that things are dropping off just a little bit in 2025 from 2024, but it's still generally holding at the same trend line for growth. But is something to watch because down just a little bit. Next page. On this, Sarah, this is data related to cases and aging report at the top of the page. I'd like to zoom into the center of the screen of the, yep. And there you can see, since we're very close to the end of the biennium, this count, because we run it close to the meeting. This information is as of May 11th. Most of the other data is only through the end of the last full calendar month of April. But this has a few more cases. And you can see where approximately we have about a month and a half left to add cases opened and closed. But you can see there, we break out the percentage of cases that are related to compact privilege holders. And the other piece that we've added, the complaints as a percentage of total population at the end of the biennium. We break it out, the two populations. So the first line, the percentage total of the license count, Oregon license holders. And then the second line is the percentage of the total compact privilege holders, those two populations and what the relative complaint rates are. This ties into what we first discussed at the March meeting with regard to the workload for your consideration about a potential change to a compact fee, which will be before you in the July meeting. Bottom of that page, and then the top of the next, just highlights some of the education and outreach activities in March and April. A pretty active time period with school visits and then some webinars and other presentations that were given. On administrative highlights on the table, there's not a lot of change since the March meeting because there simply haven't been deadlines to do that. We still are track. I do take a very conservative approach for reporting. If it's due soon, but it hasn't happened, I'll leave it yellow just to create that visibility that it is something that is due. Strategic planning update, which is simply a report filed on the progress that the board has made to date, is due June 1st. I have every expectation that we will file that report. So the outcome is effectively green, but those are the statuses there for those pieces. And finally, on this page, the other highlights are predominantly around information technology. We are on track on the major projects we've been undertaking, particularly in earnest the last quarter. The historical record scanning process for licensing files is about roughly 60% complete. More files have been pulled, but then we do send them for scanning and then verify that on, but that is on track. The equipment lifecycle replacement is on track and almost complete. And then I do have to make one modification or update for the licensing system migration. We are working with the vendor on an implementation schedule. We should still have a plan, hopefully by June, when that would happen. They've taken a momentary pause because they're attempting to have a broader conversation with the state of Oregon because there are other boards that utilize the same product. And so they're trying to frame in all of those migrations in context with each other. So that's given us a little bit of a delay, but I still expect to have some answer, certainly by the July meeting, about when things will happen. The big question for us operationally is that whether we would engage in the upgrade, the migration to the latest version of the project prior to renewals, because we have limited time before we need to have a lockdown system to go into renewals, or if there simply isn't enough time left and we would be scheduling it after the renewal period. The rest of the documents that are in the packet are related to the financials, a budget to actuals through this fiscal year. Please keep in mind that this report is just the second fiscal year of the 2-year biennium. The total amount for the fiscal year was on the first page of the director's report to see those budget actuals and how the biennium goes together. And then, of course, the profit and loss statements for March and April. And with that highlight, Madam Chair, it would be a question if there are any edits or questions, comments on the consent agenda items.
Any questions?
I don't know that we've picked somebody for motions today. Susan has volunteered.
Yay, thanks, Susan.
And do we have a second?
What do you want to do seconds? You want to do seconds? Dwight?
Sure.
Okay. Dwight's. Dwight's, do you want to do seconds? That's what I said.
So then you could entertain a motion to items as written.
Madam Chair, I move to approve the consent agenda as written.
Second.
It individually or because we're not on Zoom? Okay.
Yeah, we still need to do a
Okay.
roll call.
All right.
So it is first and seconded. Okay to do the roll call vote?
Yes.
Okay. Timothy,
Aye.
Aaron,
Aye.
Mariah,
Aye.
Sandra,
Aye.
Oku,
Aye.
Susan,
Aye.
Erica,
Aye.
Dwight.
Aye.
Madam Chair, the motion carries unanimously. Are there any members of the public in the virtual waiting room or in the virtual meeting? And any public members in the room wishing to make public comment?
I just want to say thank you. Serving on the board has been really an honor for me. It's a service to the profession that I take very seriously and probably one of the high points of my career as a PT. Being surrounded by the Oregon board and the staff has been a life lesson in caring and efficiency and professionalism. I think the proactive nature of strategic planning that Michelle leads us through is really spectacular. And as we look at cases, we're always mindful of the whole components of practice, like the art and the science and the regulations. So anyway, thank you very much for the opportunity to serve.
Thank you, Michael.
Miss you.
Slide. Madam Chair, the next item is welcome a new member.
Hiya.
Hi, I'm Mariah Frank. My pronouns are they, them, and I work for Sound Body Physical Therapy as an outpatient pelvic floor PT. Very excited to be joining the board. I think I can bring a really unique trauma-informed lens, which I think will apply really nicely to a lot of the cases we're going over. And yeah, I just look forward to getting to know you all and helping out.
Welcome, Mariah. And of course, with welcoming a new member, we also need to say goodbye to Michael. And with that, we do have a recognition of board service that we have. Gayla, if you could help us out with the magic. And then, Madam Chair, if we could ask Erica and Michael to kind of meet in the front of the room. We have the certificate. And I will take a photo.
Oh, and that's.
Next, Madam Chair, we have the delegate reports from the PT Compact Commission and the Federation of State Boards and Physical Therapy. I would like to highlight that as of May 1st, Alaska is now fully active in issuing compact privileges. And we have the special honor of being the state with the licensee who purchased the very first Alaska privilege. And with that, I'll turn it over to Compact Commission delegate and committee members to give updates.
Hello, I unfortunately missed the last meeting. I did attend 10 minutes and was not able to further attend, but I also forgot to report out last meeting that, I can't remember when our last meeting was, but March 1st, Vermont also became active. So they were the 33rd state, and then Alaska was the 34th state. So that's a lot of states that are active with the compact, which I think is pretty great. I also was reading an email update I recently received that Kansas and Pennsylvania are doing some legislation for background checks, which helps protect the public. And then Maine is likely to go live with the compact January 1st of 26, which I think is really cool. So a lot of the states are actively working to get back into the compact. I think that's really the only update I have on that. I apologize for missing that last meeting.
Sarah, did you have an update on your committee?
I suppose. Can you guys hear me okay?
Yes.
I'm the only one who I didn't sound check. So I am now the chair of the Education and Outreach Committee for the PT Compact. We have met once so far in 2025, and we're going to be meeting again soon. At our most recent meeting, we discussed a lot of some intricacies of what you guys are going to hear about a little bit later with upcoming not changes, but education pushes for information on home state, particularly in regards to military members. One thing that's really cool about the committee right now is that they have added 2 new folks to the committee who are, one of them is a military spouse, I believe, and she is a PT. And then they've also added someone who works for a telemedicine company that I believe it's Hinge Health. So getting a good overview of how the perception of the compact is in the public, which has been really interesting. So yeah, we are looking to do a big push for some outreach on those military requirements.
Thank you, Sarah. Or on the Federation side, any committee or task force reports?
Yeah, so I have also missed the last meeting due to some family issues. So Animal Task Force, I'm on. I think there's probably a question, should I still be on it or not? So,
You are still qualified as a former board member
okay,
to continue for any of the Federation work.
very good. Yeah, so I think as things settle down and we get transitioned to Wisconsin, then I can pick that back up. And then is it related to the compact? So that's the minimum data set questionnaire. There's a PT compact, PTCP MDS survey that's in development that I think is about workforce and the compact.
Not just the compact, absolutely. The physical therapy cross-profession minimum data set
Yeah.
is looking at developing, and there is a set of standard questions that have been developed across disciplines, including psychology, nursing, medical, some of the others. And the intent is that nationwide, if states can adopt those standard question sets, we can have a better a better understanding of national workforce trends. And then each of the disciplines that use that core set would develop profession-specific questions that are on top of that. And so I believe the one task force is looking at the physical therapy specific questions that would be added to that workforce data collection.
Yeah, yeah. And with the title of compact, interestingly.
There's a second variation of that that is looking at if that's sort of the standard, should or can a compact take a question set? Because it is actually a gap that we have in that our workforce data for Oregon is captured on license renewal. We know that we have about 14 to 17% of licensees who never renew. And we also know that we now have 8 to 9% of the population that hold a compact privilege and also would never report out on data. And that's, you're getting close to 20, 30% of your workforce that you have no visibility into. And so that variation is, can the compact also do a workforce survey based on that minimum data set?
Okay. Thanks for filling in the blanks as usual, Michelle.
Absolutely. And I believe for the regulatory workshop, Erin, would you like to give a debrief on that event?
Yeah, I just want to say if you haven't gone, like you need to go virtually or in person. I think in person is a different experience, but you can probably learn a ton by attending it virtually as well. I probably will try to attend it virtually next year. But the only word I can describe was it was amazing. It reinvigorated my thought process for being a member on the board and understanding my role even more. I think I thought I understood it until I went to this workshop. And this workshop is meant to be attended multiple times. So like you could attend it virtually and then you could attend it in person. And there are people that were repeat offenders that were going there, people very experienced and people that were very brand new. Anyway, it just reinvigorated my love for being here. I learned so much. I learned what surprised me the most was the variability of the boards in our country. It was like mind blowing. And then I think what impressed me the most was the work that we do. I don't know, there was nothing, I have nothing negative to say other than it was just completely fascinating. And if you have passion for the work that we do, you have to go. Like, it's just, I think it should be required is basically what I'm trying to say. I think it should be required. Maybe your employers can give you time off for it, but highly recommend it. Yeah, I think, yeah, those are the primary things. The speaker was an attorney, one of the main speakers in the morning. It was is a very engaging speaker. And I'm blanking his name, Dale.
Dale
Dale.
Atkinson.
Yeah, he's just incredible to listen to in person. Sometimes I've attended the webinars and I'm like, okay, this is interesting, but in person, it was incredible to listen to him speak. Anyway, I just can't say good things. Thank you for letting me go. So, yeah. Yeah. And we got books, like takeaway items. I brought the books to show you. I don't think you get that if you attend virtually. I haven't started reading them yet, but really cool things about regulation. There was a lot of talk also about the fear of deregulation, which I thought was something that was on my radar, but anyway, just some interesting topics that were discussed around that. Yeah.
The other highlight is the upcoming webinar and trainings, May 20th, Chevron 1 year later. That is, it's open to anyone that can register on the Federation's website, board members or members of the public or attorneys who might be interested in a focus on the U.S. Supreme Court Chevron decision about a year ago. That will be that update. The June 18th is a regulatory hour that's focused specifically on board meetings and board meeting process and best practice recommendations. That is given by Dale Atkinson, who Erin referenced. So it'll be sort of like a a concentrated one topic preview of what gets covered at the regulatory workshop. And then, of course, on our radar, this is technically after the July 16th board meeting. But to start thinking about the leadership issues forum that the delegate will attend. And if there are any specific topics or questions that we want the delegate to go and speak about or ask questions about. So as we perhaps are talking about the strategic planning a little bit later this morning, there may be topics that the board could choose to direct the delegate to bring forward to the leadership issues forum. Any questions or other highlights for delegate reports?
I just wanted to highlight that the Oregon Board of Physical Therapy is the most organized board that I witnessed when I went to this regulatory shop about just people talking about things. I was like, we're already doing that. We're doing that. We're already doing that. We're already doing that. So anyway, it's an honor to, I'm not like trying to like suck up to you, but like, it's an honor to be part of that because it was like, yeah, we're doing that. Oh, like Michelle's got that. Like we're staff, Gayla's doing that. Like we got all of it. So anyway, I'm just really proud to be here. Yeah, highlighted that for me too.
I went when I first started. So, and Erica was there and Becca. I'm trying to think. We didn't even really know each other. We maybe had one meeting or something, and it was like Oregon was like winning all these awards, and we're like, oh, there was a lot of us there besides, but we were the newbies. But yeah.
Try to do our best. Next item, and this will be just a very brief highlight because it is a main agenda topic item. I mentioned that the update on the work that you are doing as a board will be reported to the governor due June 1st. We are amazingly at the end of the horizon from our last strategic plan, a process that was initially started in 2018 through 2025. And the new planning horizon that we're going to be looking at is a 10-year horizon. Effectively, maybe the main next 5 years, which is what we've typically done. But we're going to look out a little bit further because of some dynamics that we'll talk about. One of the things, and we'll give a small report on this, the House Bill 3824, which is the bill that was introduced on behalf of the APTA Oregon Association. If the bill passes, will have a massive impact on priorities for the next 2 years. So something for us to keep in mind. Today, that's main focus of today. And one of the things that you'll be talking about and thinking about is how and when you want to handle the outreach and public input opportunities. So that'll be part of the point of discussion today. And if you're following along online or on your iPads, the link at the bottom of this page is to the current strategic plan, which will be a reference point for future planning work. Item. Under this, another standing item that we have is for roundtable topics and the identification of future agenda items. This is partly so the board can have the dialogue about things that you'd like to see brought to the board, either as presentation or discussion items, and also make that as visible to the public as transparently as possible of what's on the radar and what we anticipate to come to future meetings and when, if we know when. Keeping a running tally, the ones that are harder to read at the top are the items that have already been addressed in this calendar year. Most recently was the training completed by board members provided by the Oregon Government Ethics Commission on public meetings law. They have recently new oversight and have and rulemaking, and there's some new pieces to the law that the board received training on. But otherwise, the list that we have for future items, PT, PTA student debt trends, Licensee student outreach on informed consent. There has been some, but to have some additional discussion with partners on other opportunities for that. You've requested a survey of other boards' rules on patient abandonment, which is still pending. Further discussion of AI in regulation and of course in PT practice. And then topics related to the House bill, for example, dry needling, imaging, prescribing authority, some of the other things that if the bill does pass, to bring top speakers on those topics to the board because you'll be charged with rulemaking based on those topics. And one proposed item that we have for your consideration would be to, recommended at the July meeting, the board typically reviews the delegated authority document and other things at the end of a fiscal year. Staff recommends that we include in that review a public meetings process review so that you have at least that annual visibility into that and how you're at the same time that you're reviewing your delegation. That's one recommendation that we have for the board's consideration. But otherwise, if there are other topics or if you want to do any sort of prioritization or directions to staff on what you would like to see sooner rather than later, open for conversation at this time.
Do you have any future topics you'd like to add? You.
Thank you. The next item for general discussion and action items today, the first one is related to the next biennium, 2025-2027 biennium budget. The budget was presented to you at the last meeting in detail, and you did initiate the administrative rulemaking process as required by statute in order to adopt the next biennium's budget. That rulemaking did go out and to the public and to all interested parties and all licensees. What you see on the screen is the text of the rule that is the result of the updated budget numbers. This is the text. The only thing that changes is the update in the biennium and the amount of the budget in those references. So minor changes in the rule to adopt that budget. There were no public comments received during the public comment period. And so the question before the board would be for your consideration is whether to adopt the rule to enact the next biennium's budget.
Madam Chair, I move to adopt the proposed amendment relating to OAR 848-005-0010 as written.
A second.
Madam Chair, could we consider on the motion specifying making it effective not until July 1, 2025?
Yes, to be effective July 1st, 2025.
I second.
Roll call vote. Timothy,
Aye, yay.
Aaron,
Aye.
Mariah,
Aye.
Sandra,
Yes.
Oku,
Aye.
Susan,
Aye.
Erica,
Aye.
White.
Aye.
Madam Chair, motion carries unanimously. Okay, yes, ma'am. The next item relates to another proposed administrative rulemaking related to the a predetermination process that was introduced as part of Senate Bill 1552. And what I want to do is talk a little bit about the process and then have some proposed rules for your consideration. Sarah, if you could move to the next page, slide, please, and then zoom in at the very top of the first page for the background. In the bill, on page 30 of what I think is like a 45-page bill, there is one section that relates to occupational licensing boards and directs them to create a process by which an individual who is considering education and going into a licensed profession, if they happen to have criminal convictions at that time, before they make the investment in the educational program, can petition the licensing body for that profession to determine if any of their criminal convictions would outright prevent them from ultimately becoming licensed. I believe it was Senator Dembro's bill in bringing this forward. So that's the intent of it. Based on the statutory language that's introduced in the bill, what we have is a draft process based on model language from DOJ. The first one lays out that prior to beginning the required education or training. So the one limit in the statutory language is this would only apply to individuals before they begin their program. So it would not apply to individuals who are in their program where something may happen where they could petition there. The payment of any applicable fees. We are not recommending a fee per se at this time because we want there to be public input and public notice on it. So the idea is there's a referring to your section on fees. You're considering other fees at July, so you will discuss the fee for this process at the July meeting. So this is just the procedural rule that goes into effect. The statute is pretty clear on the specific records that are required to be provided by the petitioner, which are outlined in Part C. And then if you can move the scroll, Sarah, thank you. A written statement about the facts and any other documents that are needed. One of the recommendations is that it's possible that there may be an individual that has multiple convictions, but in order to consider each fully, they would submit a separate petition for each conviction with all of the relative documentation. 4 introduces that if records don't exist or are sealed or something else, that there is that attempt that the verification from the authority that is true and an accurate representation. And then over to the next page, please. There are some time limits on this. If there are missing materials that are still needed, a limit of 60 days to provide those. Otherwise, it'll be, the petition would be closed and they would need to start over. 6 then goes into language that is really an important point, is that there was nothing in the statute that makes this application process confidential. And so there's that recognition that the determination, the petition, other than things that are personally protected by other laws, that this is open public information. 7 introduces language about reconsideration of a determination. And this gets into establishing that if things change, if there's additional criminal convictions, if it comes to light that not all the information was provided, there are additional facts. And so that's what you begin to see here under Part 8. Part 7 also states that that this is just a predetermination, so the board does fully reconsider things when there is a full application. A predetermination does give them the information, but there can be changes, and so there is a process of reconsideration on full application. And then if you scroll a little bit, Sarah, to see the rest of Part 8, you can see some of those instances that I was describing about new convictions or additional information. And then 9 is just some additional language about failure to disclose and the consequences. And number 10 is just a clarification that there's nothing in this rule that would prohibit a board for denying licensure for any other reason beyond the scope of that predetermination. And it's not considered a final determination as in the form of a final order, anything that leads to vested case rights, or that those don't exist for this process. And then the last piece is just the statutory authority for this. On the next slide, Sarah, please. So as far as if those are the administrative rules, some considerations that we have for the process itself, we propose as staff, at least right now, that the predetermination process be handled as a manual process, which means not create a new pathway in the online licensing system to capture the information, but if they maybe a PDF form that they fill out and work with us. We don't really have any sense of what the volume is going to be. So it may be something that it makes sense to make the system investments to automate the process. But in the meantime, that's our recommendation. We've also talked about, in addition to simply putting information about it on the board's website, we think that it would make sense to propose outreach and partnership with at least the Oregon educational programs, if not more broadly, to make them aware of this option because it really only applies to people before, right, they're enrolled. And so if we can, this could be something that the schools, we could ask them to let folks know as they are interacting with candidates.
I guess that was my question, like in number 1, how do you define beginning that? Because students go through the application process. You know, I've was with Lane and then OIT for many years. And it's like, we say it during the orientation, but they're only sitting in orientation because they've already said, yeah, I want to be in this program. So have they already begun their training at that point? Or is it before you've taken, you know, that if they could withdraw from the program at that point? How much? Yeah.
Yeah, Susan, I think that's a great question. We're a little hampered because the language in the statute is vague. It says beginning a program. What that does do, though, is create some, I think, interpretive latitude for the board to determine when that point is. And I think it might be helpful in the process of outreach to work with the schools and help decide what that is. Because I could see it could be enrollment, it could be by the drop date, it could be, I mean, I could see an argument made at any of those points. And another consideration for you to discuss would be whether you want to delegate authority for making the predetermination decision to staff that would then be ratified by the board at the next meeting, or if you want all petitions to come before the board in public session. We put that out there and you could talk about it in more detail, meaning you wouldn't be deciding today about that delegation. You could discuss options, but a decision about if you wanted to delegate, you would, when you review the annual delegation authority document, you could make a change there. And I mentioned the fees, that's the last piece of it. And part of what we could provide is kind of an estimate of what we think the workload will be. And we can kind of bring that estimate to you and you could decide, establish the fee in July, meaning the proposed fee, it would still go through the full administrative process. I think, Erin?
On the delegation piece, I think if we're going to talk about it more in July, I just had a question on if other people have this in their jurisdictions, what they're doing. It'd be interesting to know what boards are doing for the delegation piece.
Sure. And I mean, you can absolutely talk about it now, but you wouldn't make
Yes.
a
yeah.
decision until
And,
July.
and we could wait till July, just imposing the question.
Oh, no, no, no. I think it's
Yeah.
great to discuss it now.
Yeah.
Oregon.
Yeah.
I'm
Or
wondering across the country.
across the
too.
country as well. Yeah. And the delegation piece on this specific, yeah, statute.
This is Joanna. There are other states. In fact, I think Utah was the model the legislature talked about
In Texas.
that allow this in Texas. But we could look. I've looked at the Utah rule. The other thing I was going to say on the delegation of authority, I think it might be encompassed there, but to make it clear is you could also potentially look at what you're delegating to staff in terms of approval of applications now. So you would see the kind of convictions that would come to you if the person applied, but delegate to staff those convictions that you delegate now to approve licenses.
Yeah.
Yeah, like if somebody has like a shoplift conviction from when they're 17, 20 years ago, I think that's delegated to staff to approve right
Yes,
now.
yes.
Yeah, exactly.
Yeah, that's a great point, Joanna, that it can be within guardrails or to certain limits. And the statute delegates the authority for this decision-making to the boards. And then different boards are taking different approaches. The only way staff can make a decision is through the specific delegation of your authority to staff through that formal action. Some boards are in Oregon are choosing to do that in part because the petition is public. And even though it's still public information, even if staff makes the determination under your delegated authority, it isn't published in the public meeting materials. It's still a public record and can be available by request, but that's one consideration that they're doing in that process. Yeah, because this information is public information under public records law, some boards are choosing to make the preliminary review with that delegated authority and whatever those decision guardrails are to staff. Because otherwise what happens is if the board is reviewing the petitions in public session, it has to be in public session. And so that means it's part of the public posted materials by default. Yeah, you could, things like social security numbers, there's some information that you can redact. And that's also, staff would need to go through and redact out restricted information in order to create the public packet that's then posted essentially online. And so some boards are choosing to do that in part to give the petitioner a little more privacy, even though what's important for petitioners to understand is it's public information. And so anybody could request it. It's just a little bit different not to proactively publish it in order for it to be considered in the board meeting. But not everybody is choosing that. There are boards that are still planning to do to not delegate the authority and to do the petition review in public session. And I do know that Texas, at least the Texas PT boards, they have delegated authority for the predetermination process. They've been doing it for a long time, so there's some automation in it. They've even said, if it's this kind of conviction, then, there's a definite, you can still go through a petition process, but odds are not in your favor. So pretty much any model that you could think of.
I can tell you, I get a lot of emails like this. Yes, I do. And we can't have an answer now, but I do get, I would say at least 5 or so a year from people who are like, you know, should I bother to go to PT school? It's expensive, or even PTA school. And am I going to get a license after I get out of school? And I also get calls from maybe like counselors who are working with people who are trying to decide what kind of profession to go into. And they're asking, you know, I have a client or somebody, a therapist, somebody I'm working with, and they want to know, you know, they're trying to decide what path to take. So I would say it comes up at least like 5 to 10 times a year.
And I know in the programs, like the coordinators for clinical education talk about it from the get-go. I mean, because they can't place students who have these kinds of things. So I don't know if that gets filtered some out. I mean, they don't make that judgment on licensing, but they bring up the exact same things in terms of, tell me now, because you're going to go through a whole year of school and I won't be able to place you at a clinical setting. So it, you know, I don't know. There's a lot that comes up through that.
I was just wondering on Susan's comment from before, can schools have that as part of their application process? Like, is that within the bounds of the law
Meaning that they would require,
before they've been accepted?
that they would require them to go through the board's predetermination process?
Like a school could have, you know, have you been convicted of a crime? We encourage you to follow this link to predetermination. That's
Schools
okay.
schools could absolutely choose to do that.
I know that many employers require a background check prior to the student attending their facility.
Also, in some facilities, like Susan was saying, people can't work if they've had like skilled nursing facility, any place I think that bills Medicare, doesn't allow someone with, so even if we gave them the okay, they get to school and then they can't place them in a clinical setting. That happens often.
The question before you today is whether to initiate the public administrative rulemaking process pertaining to the predetermination requests, to get that out there and get the public input on it. Any final decisions that you make about these considerations, you can pick up again at the July meeting to make a final decision on those.
Madam Chair, I move to initiate the public administrative rulemaking process pertaining to SB 1552 predetermination requests.
Second.
Motion's been first and seconded. Roll call vote. Timothy,
Aye.
Aaron,
Aye.
Mariah,
Aye.
Sandra,
Aye.
Oku,
Aye.
Susan,
Aye.
Erica,
Aye.
Dwight.
Aye.
Madam Chair, the motion carries unanimously. Next item is similar. This one relates to the federal law, the SERA, which is the Service Members Civil Relief Act, and proposed administrative rules and process related to same. Sarah, next slide, please. This one, and Sarah has put together kind of a great chart on this. The federal law for license portability for service members and their spouses, the intent is if a service member receives new station orders and needs to change residence to Oregon, and if they are a licensee of your board or their spouse or in Oregon, the equivalent domestic partner, then they're trying to provide a pathway to have them be licensed as quickly as possible when moving to that new jurisdiction. Essentially, it creates a reciprocity or an equivalence, and it requires jurisdictions to accept licenses that are in good standing from the other jurisdiction for the same practice, essentially without any other barriers for the duration of the military deployment. It does require, though, that if the service member or spouse is coming from a compact state that's a member of the compact, that they must use the compact as the pathway for portability. So in Sarah's spreadsheet, or I'm sorry, flow chart here, the first decision is, do you have a license in another state? If not, going down, then that's the standard licensing process. If you are licensed in another state, then you have those court orders. If no, are you in the compact? And then it's either qualification for compact or standard licensing process. But if you have a license in another state, you have those orders to be deployed in Oregon. And your home state is in the compact, then you have to go compact. If not, you can do either the standard licensing process if you want to, or the SCRA pathway. And then if you're a military spouse, you have even another option because there's an existing Oregon law for a military spouse temporary permit. So what this is trying to, as a first draft, is to try to create like a communication pathway, or it could be a branching survey questions, like where folks could answer yes, no, and then it would give them their options for licensure in Oregon with the SCRA. Next slide, please. This one, and for board members, I should probably have pointed out that I did push out these individual documents to your iPads if it's easier to bring it up on the screen. Apologies for not saying that earlier. This is a tabular view of the application requirements, fees, how renewals apply if they do, and a sense of processing time. And Sarah, could you maybe zoom in and we could slide over to like the compact and the SCRA portions? That works.
Guide me as much as you
Yeah.
need.
So here you can see that application requirements for the compact, they need to complete the JAM under the SCRA by federal statute, fingerprint-based background check, proof of service orders and intent to reside, proof of spousal relationship if applicable, and then verification of all licenses and attestation. And when we look at the rule, I'll give a little more detail on that. Moving over, for the compact, you currently waive the state's portion of the compact privilege fee for active military and spouse of active military. That is half of the $95 fee that they otherwise pay. But there is that a $50 portion that goes to the PT Compact Commission. It doesn't come to Oregon, it goes to them. Then the next renewal information, compact privilege renews with their home state license. Under the SCRA, it's for the full term of the deployment. However, they would need to renew the qualifying home state license if it happens to hit a renewal while they're here. And then processing time, which is the next information, compact privilege can be issued same day. And our processing time for applications is usually same day we have everything else, but officially within 2 business days of having everything. And then how to apply. Compact privilege gets purchased at ptcompact.org. You'll see when we talk about it right now, we're recommending contacting board staff until we are not expecting a huge volume. There just aren't that many deployments in Oregon. So kind of a hybrid process. But the rest of the table goes through this information for the standard licensing process and military spouse permit. Again, this is a preliminary view of what we're anticipating the public information would be so that folks can make a fully informed decision on what type of authorization to practice they're interested in Oregon. Next slide.
Context, just not anticipating a ton. I think we've only issued maybe under 10 military spouse permits within the last 6 years that it's been available. So
I think closer to like
okay,
3.
I didn't want to
Yeah.
go way under and then be corrected like, no, it's been 50. But yeah, it's similar expectation, which is part of that annual process guidance.
Yeah, absolutely. This slide, Sarah had alluded to this earlier. When we talk about PT compact home state, it's a little more complicated of an answer when you're military as to what can qualify for your home state. Because it can be the official home of record in the military personnel file. It can be your PCS. Now, in this under SCRA, it's a little bit different because they are being deployed to Oregon, which becomes their PCS, but that you can't have Oregon be your home state. That would be the one loop there. And then, of course, the state of current residence or deployment. And that's context for then the next page, we start into the draft rules in order to implement the federal law. And I don't think I mentioned this. We did reference it, I believe, at the March meeting, that this was originally, I think, passed in 2022, maybe early 2023. But the law was revised pretty significantly federally in December of 2024. And so these rules are drafted specifically to implement that most recent version of the federal law. Background, and I think I've referenced all of the information there for background. So if we go to the draft rule, there are some definitions. Because of another Oregon state law, any law that applies to spouse applies to anyone with a domestic partnership registration in the state of Oregon. And so for the purposes of the SCRA permit, as it does for the military spouse permit, that would apply. Definition of service member, spouse, and then state. When we say state, because physical therapy is licensed in District of Columbia, Virgin Islands, and Puerto Rico, anytime it references state, we just mean all of these jurisdictions. The point 2 is what references that if they have an active license in another state that's a member of the compact, then this section doesn't apply to them. So then in order for it to apply under part 3, if we go down, or I guess it's over to the next page, they have to have an active license, and this is now all from the federal requirements. They have to hold an active license to practice in good standing. They have to not have ever had a license revoked or had any discipline imposed in any state licensing authority. So if they've ever had discipline, they don't qualify under SCRA. And there hasn't been a voluntary surrender while under an investigation, meaning it didn't result in disciplinary action because they surrendered it before that could be resolved. They also won't qualify. And then E is just referring back to they can't hold an active license in a compact state. Under part 4, if you meet the requirements, And I'm pausing because I think the federal law. Yeah, in Part C, I'm sorry, can you scroll back, Sarah? I want to make sure that I highlighted this properly under Part C. That you can't have any unresolved active investigations either. So that's a little bit different in that right now, if we do license verifications, it only references if disciplinary action has been taken. This process, the federal process, requires us to verify with those other jurisdictions if they have an open case. And if they do, then the individual doesn't qualify. Thanks, Sarah. Part 4, then it just lays out the requirements. These are also as described in the federal law. They need to complete the application for the board. If it's the spouse or domestic partner, there has to be the certificate or evidence of the domestic partnership. Proof of military order for military service in Oregon. Because of the way the federal law is written, proof of intent to establish residency in Oregon. So if they're deployed to Oregon but choose to live in Vancouver, Washington, they don't qualify. And then there is an affidavit about that they read and understand the licensing requirements and scope of practice. They'll meet and comply with the Oregon laws governing the practice of physical therapy, that they are in good standing. So these are the attestations similar to what we have on ours. And if you go to the next slide, Sarah, to continue at the top there. Clarifying they have to maintain their qualifying active license for the duration of the orders, including any renewal if applicable. And that if requested, they will provide to us the verifications that are required. We can do a lot of verification of licensure to automate that for them, but there are some cases where we'll need that information from them. This authorizes us to acquire it. And submittal of the fingerprints and the criminal background check. Part 5 notes that the board will review and act on the information provided in accordance with the rules adopted. In addition, anything adopted under this rule, that you'll review and investigate the application to determine whether they meet the requirements, including verifying the veracity of all documentation, and that you might deny an application if they fail to meet the minimum standards that are laid out in this rule and in the federal statute. Part 7 indicates that the board will monitor applicable systems. This will include the ELDD through the Federation, the National Practitioners Data Bank, or any other source of verification. And Part 8 is a requirement for disclosure should anything happen after they've been licensed to us. And that they're responsible for providing the board military orders ending their service in Oregon. That the board may investigate or take disciplinary action in Part 10 for any violations. And Part 11 just clarifies that if they've been authorized to practice under SCRA and they wish to continue to work in Oregon past their deployment for whatever reason, that they have to apply for the appropriate license. Top of the next page, please. And then Part 12 just emphasizes again that a person who's qualified under this rule doesn't have to apply under this rule, and they could choose any of the other licensing pathways. And then the authorizing authorities for implementation. Other considerations on this one, the old version of the federal law did allow jurisdictions to require completion of continuing education, continuing competence requirements. Those sections were removed in the December 2024 update. And that's part of why you do not see a reference to completing any of the otherwise required pain management or jurisprudence exam, is there does not appear to be the authority to do so. Staff are proposing that this permit be handled as a hybrid process, meaning that we wouldn't alter the licensing system, at least not at this time. That we would be directing them to contact us for assistance, but we do anticipate putting their record into the licensing system. There are just some things that we are going to need to do on the back end to help facilitate that, since they won't have to complete all of the requirements that other applicants do. And, you know, once we have a sense of volume, then we can make other operational decisions, but that would be our recommendation for the process. We also recommend developing a specific web-based landing page with that flow chart or that Q&A and some of those other things to really help military folks understand what their options are and make it just as seamless and as easy as possible for them when they're being place shifted. Staff is also recommending that there's no application fee for the permit. We are recommending that they still pay like the background check fee and some of the other incidental fees. And the reason for that is that it would be consistent with what you already have decided to do in waiving the state compact fee for active duty military and military spouse. But that's just our recommendation, and you could further discuss whether there should be an application fee at the July meeting when you're talking about fees. That's the overview. Any questions or discussion?
I have a question, and I feel like maybe everybody will know the answer but me, but I get why this is an idea, but it's so licensing happens so quickly nowadays, you know, with why would somebody want to go this route?
Sandra, thank you. I think from a federal perspective, because this applies to all occupational licensing with the exception of law, practice of law, and there is huge variability in what the requirements are for other occupations. Some of them require a minimum number of like clinical practice hours. Some of them might require like an apprenticeship or a journeyman hours or other requirements. And so for individuals in the military who are forced to move, sometimes it can be months and months and months before they can acquire a license in that new jurisdiction.
Okay, that helps.
Yeah, so even though our processing times are very quick in physical therapy, and that's pretty true across the nation, they're because they're applying it to all occupations, and that's why.
So would most physical therapists that fit this, would they use this rule, or would they just go ahead and apply for a license?
I think it's a great question. I think that the fact that physical therapy is one of either 2 or 3 health professional occupations that participates in a compact. And you know, we have 34 states that are actively issuing now, and another 4 or 5 states that are trying to. So that means that most folks are going to be coming from a compact state. California is a very large exception where there's a large military presence, and so they might be coming through this pathway.
Okay.
But I think as the compact, as more and more states join the compact, the need for this law gets smaller and smaller.
Thank you.
Absolutely.
Can I make a comment on that? Like I said earlier, on that committee, that the PT Compact Education and Outreach Committee, there is now a military spouse. She spoke very highly of the compact and basically was like, I'm preaching about this to everyone who will listen when they get orders. So I think, again, yeah, for the PT profession, I don't see this being used significantly except for those folks who don't have access to the compact.
Okay.
I'm curious, I appreciate the way to provide these people with opportunity to practice in our state. I have this inkling or have thought that maybe the compact or potentially the SCRA permission to practice doesn't hold the same clout in regards to contracting with payers. And I was curious if anybody had experience with that, because I thought I had heard that you can't always get contracted with a payer as a compact holder in certain physical therapy settings.
That,
The pair?
oh, payer.
Okay.
Oh, sorry, yeah.
No, great clarification,
Yeah.
Dwight. What I can say is, that has been changing. Absolutely at the start of the compact. I think Oregon was, one of the first 3 states that went live, the first that enacted the statute. Nobody understood it. The different types of payer didn't understand it. And there was a lot of outreach and letters to Medicare, Medicaid, and individual insurance providers about the equal nature of the compact privilege and the jurisdictional license. With that said, we do occasionally sometimes hear employers that have an employer preference for one or the other. I think sometimes they may have established verification systems for their employees, and they're used to going to the jurisdiction's website. And so it's easier for them to keep track of, particularly when the compact privilege is tied to other expiration cycles. It makes it harder to manage. So I think it's an employer decision, more from their internal sort of QA process. But it's rare that we hear reports of folks or whole large payers that don't verify them. Yeah. Yeah. So with that, today, the only action would be consideration of initiating the administrative rulemaking process to get public input on these rules. The remaining process or fee-based decisions would be on your July agenda.
Madam Chair, I move to initiate the public administrative rulemaking process pertaining to the implementation of the Federal Service Members Civil Relief Act.
I second.
Motion is first and seconded. Roll call vote. Timothy,
Aye.
Aaron,
Aye.
Mariah,
Aye.
Sandra, Oku,
Aye.
Susan,
Aye.
Erica,
Aye.
Dwight.
Aye.
Madam Chair, the motion carries unanimously.
Time is 10:04 a.m. and the Oregon Board of Physical Therapy is going to take a 10-minute recess. So we will be back at 10:14. Okay, the time is 10:20 a.m. and the Oregon Board of Physical Therapy is back in public session.
Thank you, Madam Chair. The next item is the 2025 legislative session update. Next slide, please. Some general reminders and for new members. The board itself has no agency legislative concepts, but the board does support the governor's legislative priorities and recommended budget. Those links are clickable for anyone looking at the materials to review those priorities. It's important to remember as a board member that all executive branch agencies do not take positions on any bill unless, of course, you were to have your own agency bill, then you have a position. But unless you're otherwise directed by the governor. And that is a different stance than being neutral on a bill. Being neutral is still an opinion. So it's no opinion on any bills. Agencies can discuss bills in general or provide technical feedback or testimony to the legislature or in your public sessions. You can discuss them. And you as board members and staff can advocate personally on any bill. There's nothing about your service or our employment that prevents us from participating in the legislative process. As a board member or as a staff member, we are required to identify clearly that it's a personal opinion and that we, even if we are staff or board members, that we are not testifying in that capacity, but rather a personal piece. The governor does ask that if you are planning to take a position on a bill, that you just, as a courtesy, let her know through that office that you can do through me or through the policy analyst. There are some links here about how to track different bills, how to find your legislature. And then second to last bullet point, we are very close to the deadline for second chamber policy committees and for bills to be moved out of those policy committees. Bills can be moved into other committees such as Ways and Means, Rules, Revenue. There's a couple of others that are where if they get moved out of a policy committee into those committees, those bills can still move forward sometime before the end of session. But anything that ends up not moving out of a policy committee is then dead in that process. We did lose some bills that we were monitoring in the first chamber committee, but we're very close to the work session deadline for second chamber. Any questions on sort of the general resources and processes? Mariah?
Since I already posted my testimony for the last bill, do I go in and delete it, edit it?
Not at all.
Okay, just
not at
let
all.
it go.
Yep.
Okay.
Yeah, appreciate that though. Next slide, please. So for context, in the long session, we started January, constitutional sine die or last day of session. It cannot go any longer than the 29th of June. Frequently legislatures end earlier, often about mid-June, but it depends a lot on the context of that particular session. There are thousands of bills that were introduced. There are still not as many, but still thousands of bills that are moving through the process. And the other piece to keep in mind is that the Oregon revenue forecast, which came out just a couple of days ago, has some budget implications for state agencies. Oregon is not in a recession, but there are some concerns and some impacts. And so all of the other non-semi-independent agencies or the regular state agencies go through their budget process. Their budgets are considered as part of the legislative process. Those are all in process. Many of the agencies are being asked to enact their 5 or 10% across the board cuts that are put up on offer as part of the budget process. The legislature may or may not enact those when they're considering and approving those budgets, but that's the process that we're in right now. Because there's a lot of effort in that and a lot of interconnected parts, that may drive the session closer to constitutional sine die. The other thing that means for us is that the estimates that we use to build our budget, which we had to already have done, may change. So that could affect things that are our overhead. It could change the costs for attorney general charges, rent, information technology services. So those kinds of things that we get from other state agencies may change. So in July, if there's any significant variance that would have a budget impact, we should have a sense of what that is for your July meeting. And then the bill deadlines that are highlighted there, you can see that we're through most of them except for May 23rd, which is the last day that a policy committee can hold a work session to move a bill forward. So the list that there are a number of other bills for general government rulemaking and other things that may have an impact and that are moving forward. But we've been highlighting in the minute meetings bills that have an impact on the profession regulated by the board. The big one that we've referenced previously is the association chapters bill, which is a massive bill that would rewrite the Scope of Practice Act in ORS 688 based on the Federation's Model Practice Act. It also introduces new scope of authority in other statutes as well related to dry needling, imaging, vaccination, issuing of disability parking permits, and prescribing authority for durable medical equipment as some highlights. That passed easily out of first chamber. There have been Senate hearings that have been held over the last couple of weeks, and there's been a significant amount of testimony, both in support and in opposition of the bill. I think the most significant opposition to the bill is specifically to the dry needling, vaccination, prescribing authority for DME, and I think a little bit on some of the components or at least some questions about clarification about imaging. The work session is scheduled for the 20th, so next Tuesday at 3 p.m. in the Senate Health Committee. And my understanding is that they're based on the committee chair has asked the different parties to work together to propose amendments. So I am expecting there to be amendments to the bill. I am not aware of what exactly those amendments will include. What can often happen when there's multiple parties on the spectrum of support and opposition is that there often are drafted multiple amendments that do different pieces of different things. And that leaves the committee the option to decide to, if you will, turn on or turn off different components of the base bill. So if they're able to draft amendment, my sense is also though saying that if they do not get amendments drafted in time, it doesn't sound like the committee was interested in the bill as written without at least some amendments to it. One of the amendments in talking with the governor's office that we've requested on behalf of the board is a extension of the implementation date. Because right now when they drafted the bill, it effectively became, it would go into effect January 1, 2026. I don't think it had an emergency clause to go into effect on passage, but I think the bill would go into effect January 1, 2026, which given the significant amount of policy discussion and rulemaking that this board would need to do to implement even just the shifting of the definitions in the Model Practice Act, let alone some of the new authority that could be part of it, is just not possible. So working with the governor's office, we have requested that an amendment include an extension of the implementation date until July of 2027. The board can take actions to implement the bill prior to that date, but that would be the effective date for any of the new authorities that are in the bill. Any questions on that bill before I move on? Okay. okay. The, what, I'll explain that. What, I was going to refer back to your future topics list. And what I was going to suggest is that if the bill passes and it includes all of the elements that it does now, that I think the September meeting would be a great opportunity to have the topics that you'd identified for future topics, to have speakers come in and give kind of a background on those elements and what it would represent. So that's all I was almost not saying. The updates on the other health professions that had compact bills, I don't believe any of those moved forward. It's possible that some of the ones that are in behavioral health, some form of those might appear in other bills, be amended into other bills. But my sense is all the rest of the compact bills are not moving forward this session. Anticipated bills related to data equity and workforce. That one was referred to Ways and Means back in April. It is still viable. And the same with the impaired practitioner program. That's in Ways and Means as well. So we may see that continue to move forward. And the bill to require health insurance to pay providers who are joining an in-network practice the same as those providers. So that has already passed both chambers. The Senate president has signed. The next step is to go to the governor for that. But that one seems to have a clear path to have been through the process already. So that's your update on the bills that we've been following session. A lot's going to happen in the next week. So I should have some final info for you for the July meeting. Okay, next slide. So then for the forecast of the rulemaking, which the board does at each meeting now to give the public a sense of what may be coming, I've made a few minor adjustments on this. You can see the active rule amendment, and there's an error on my slide here. It would be effective July 1 if adopted. You did take that action earlier. And you did move forward the two additional bills that are listed there in the April to June timeframe. Those processes are being initiated now. They will come back to you at the July meeting. So they bleed over into the calendar for July. Your July 16th meeting is when you would review the public input and decide whether to adopt those rules that are being proposed now. And then July through December, it's kind of a big unknown because of 3824 and particularly not knowing what the implementation date is going to be. So everything else is kind of on hold as far as we had deferred from the first quarter, the continued work on the rules related to discharge, continuing with that rules advisory committee. Because the underlying statutes may be changing, that work has been put on hold. And we do also know that the Physical Therapy Compact Commission typically updates their rules in the October timeframe. If they're considering any rule changes, I don't know if they will be, but that would be something that under the compact, this board is required to review, give input on, and then adopt into Oregon administrative rule, either the rules as published by the compact or with any carve-outs that you may wish to take. But otherwise, we're anticipating that everything, it will be impacted by the legislative session. So the other observation I can do is that at the July meeting, we'll have a much better sense of what the administrative rulemaking calendar will be. But if there's any questions or concerns about this, otherwise this list gets published on the board's website so the public have ongoing access to that and what to expect. All All right. Now the fun stuff. Now we're going to shift into the strategic planning work session for the morning. And Sarah, can you switch to the other slide deck, please? We're almost through the me talking portion into the you talking portion. So, so get ready.
Do we have that information on our iPads? Six.
I don't know if I pushed out this slide deck to the iPads. Much of I think most, if not all of the slides that I'm going to have up here are in the board strategic plan, which should be on your iPads, but you can also get to it from our website. Bet.
Well, do you think it'd be under resources on the iPad? Or
Most of this is just informational. It is in the current strategic plan, but most of what folks are going to do is discussion. Good. All right. Next slide, please. This is the beginning of the strategic plan, and it's just a reminder that the Board of Physical Therapy established this methodology or this philosophy when it began the process in 2018, that really fundamentally the whole purpose of this is to make sure that we're doing the right things at the right time, but in the right way. So the process that this board has used historically is to prioritize, to communicate, and then to follow through on the discussions that you have today. Prioritization informs the long-range planning and policy, the rulemaking, and the legislative agenda. So it is our blueprint or our roadmap that you review at each board meeting to make sure that the actions that we're taking day to day operationally are in line with your policy direction. The strategic plan, the process, and part of the reason that you decided to have the strategic planning update on every public agenda is because it's also a way for you to communicate with community members and for them to communicate with you and have input on where things are going. Of course, all of this information is what's used to inform the operational plan or the programs and the budget priorities for the day-to-day implementation of your strategic direction. So that's the why. Next slide. The planning process that the board uses is the outcome here is not to create the strategic plan that gets submitted to the governor or posted on the website. The planning process is an ongoing process. It's not just a one-time event. With that said, at least every 5 years, the board does step back and kind of consider a longer-term view and then makes updates or a new plan based on that. But the real purpose is for you to have that line of sight and that articulation of the strategy and the direction that you want the agency to go in. So confirming our purpose, really thinking through how well are the programs and how well we're performing that, how well are they meeting the purpose, our statutory purpose that gets read out at every meeting. And doing an external scan, right? Opportunities and threats. What's changed? What's happening? Obviously, if the underlying statute that has given you the authority changes, that's a significant consideration to take into place. Once you step back, you consider all of that information, see how you're aligned with what you're already doing. There's that preparation, which is identifying any priorities and key dependencies that you need, doing the research, doing the collaboration, reflecting on all the information that you will bring forward through this process. And then it's mapping it out. Where are we now and where do we want to be? And what does that look like? And that becomes what gets codified into the strategic plan that gets posted and that you reference at each meeting. With that, you use it to plan our budgets, to make the projects that we invest in, and tracking to make sure that we're hitting those goals. But again, can't stress enough, the purpose is to continue to adjust and adapt and grow, because what we discussed today will not necessarily carry all the way through 10 years. Things are going to change. Boards, you will need to adapt. Those that follow you will need to adapt and make changes. Questions so far? Next slide. So step one, we're going to step back and look in detail at the statutory purpose. And Sarah, on this, it might help if you can zoom in a little bit so it's easier to see on the left side of the screen. I don't know. What this slide does is it goes through and it actually pulls language directly out of the statute. I am pulling out of both 688, ORS 688, and ORS 676 as reference for this. And in the written strategic plan, if you're looking at that, it does give you each individual citation in more detail. But if you boil several pages down onto one slide, the board was created to provide for state administrative control, supervision, licensure, and regulation of the practice of physical therapy in this state, and to serve and achieve the primary purposes of promoting the quality of health services provided, protecting the public safety and welfare by ensuring that licenses practiced. This one should sound pretty familiar. And addressing impairment among licensees. All of that language comes directly out of Oregon statute. The board shall also, in 676, establish programs to increase the representation of people of color and bilingual people on the boards and in the professions that they regulate. Such programs must include activities to promote the education, recruitment, and professional practice of members of these targeted populations in Oregon. Must encourage the development of state-of-the-art multidisciplinary pain management services and the availability of these services to the public. And there's a statutory prohibition for you to actually issue a license unless the individual has provided the requisite workforce data. So if you back up, and Sarah, if you show us the words on the right side of the slide, the statutory purpose boils down to quality healthcare, public health, safety, and welfare, addressing impairment, increasing representation, pain management for the population, and workforce data. Thoughts, comments? No, not necessarily. Those are just the concepts that the legislature holds you accountable to making sure you make happen. But it's not like the first thing listed is the most important. Yeah. Other thoughts or comments? I think one of the observations that I always have in doing this, because obviously my day-to-day is very operational and very centered on licensing and practice. But when you really step back, you, the board, have a very broad charge that's really about quality care and public welfare, and safety, and health, and representation and things that are outside of your direct jurisdiction authority, and so there's also an implication of the need to partner in order to accomplish some of your statutory mission. Next slide. So the other work that this board has done is to create a framework or a lens on your statutory purpose. And the first one is this concept of trauma-informed regulation in the context of all variations of the participants in the interactions of the practice of physical therapy. So that means, how does the regulatory system that you oversee impact or take into consideration the needs of patients, licensees, complainants, board and staff, everybody that has a party in the product, if you will, of regulation. So what is your role as regulators in addressing trauma in all those different populations? How does the regulations that you create need to take trauma into account? What policies, standards, practices need to address those in order to address public health, safety, and welfare, right? And so this lens or this framework was a way that this board has established that when you're considering a priority, it's just another lens or another framework that you can overlay before you make a decision and consider, how does this impact patients? How does this impact licensees? How does what we know about burnout in health professions impact patients? And what role does the regulator have, as an example, in addressing that for public health, safety, and welfare? So a framework or a lens. The next slide. In this framework of trauma-informed regulation, we did some terms definition, and this was based out of work both from the Federation and APTA and the Nursing Association and some of the federal agencies, NIH. But even though these terms are often used interchangeably when talking about trauma, this is just another rubric. And Sarah, maybe like zoom into like burnout, compassion fatigue. Part of the reason that that the board has defined these terms is that it is easy to kind of use them interchangeably or kind of roll them all up. But the drivers or the impacts from these different types of trauma can be different. And so understanding that or taking that into account can also be an important part of the consideration of what you're implementing. So we don't have to go through all of them, but you can see just with highlighting these two, the distinctions that are being made in the definitions that are being used. And again, this is in the existing plan as well. You guys, do you guys want to see before we move on? I will say in behavioral health in particular, vicarious trauma is a very large consideration for mental health professionals, having impacts of vicarious trauma.
Can you go back to the one before vicarious?
Moral injury.
There we go.
So what this talks about, you normally see instances of this, and Nancy Kirsch from Rutgers does great presentations on moral injury. And what can happen here is if you have an individual that has a moral code or a definition of how the world should work, and with health professionals, it can be to help patients. And so a moral injury can be if they work, let's say, in a healthcare system that has very aggressive productivity goals, where they feel that they're not able to do the work they want to do in the way they think is right. And so they're not burnt out and they're not necessarily experiencing a direct trauma of some point, but that sort of mental schism between what they think is right and what they're being asked to do or what they feel they're being required to do. And that creates a moral injury that can then impact behavior. And sometimes in the example that I'm using, sometimes that can manifest where they may try to bypass the system or help the patient, even if it's the right thing to do, but maybe not what's required by the process. Okay. Next slide. So what you have now are three different lenses. I dug in detail with trauma-informed regulation. Culturally responsive regulation it uses the same populations, the same framework, but the perspective there are treatment or care or regulations that are responsive to the needs of individuals that come from different cultural perspectives. And to make sure that's also a lens that we're using. And focus on prevention is a fundamental philosophy that this board has established, that when there is a regulatory choice being made, that the greatest impact is to prevent any kind of violation or harm from happening in the first place. And that is worth putting energy to avoid a problem before it even happens. And go back one, these were defined as strategic planning initiatives or the large categories that in the past, all of your projects have mapped up to one of these three areas. Next slide. Last framework that I want to make sure to highlight is the state of Oregon as a whole has a diversity, equity, and inclusion action plan that in of itself has 10 strategies that are a framework or a set of questions for agencies to use when they're developing plans. And these strategies, you can see if number 5, just to highlight, utilizing disaggregated data as a lever for change. Work that you've done with your prioritization of data analysis and bringing presentations and looking at everything from complaint categories and changes that you've made there to workforce or working with schools. That emphasis on data was part of strategy 5 that's part of the DEI plan. So this is just another reference tool that as you have gone through your planning processes, you've mapped your work to these strategies as well. So think out. If we think out, Sarah, can you drop the video like just somewhere into the white space? Yeah. I want them to be able to see 2035. Oh, no, not Zoom, just move the video. Sorry. Zoom out. Move us, yes. There we are. I know. Thank you. Yeah, Sarah is operating the entire room from a very tiny laptop screen. Yeah,
You're doing great.
yeah, doing great. I wanted to start here and make some notations as we talk through this, that if we look in the 10-year timeframe, the reason the even years are bolded is because those are when renewals happen. So there's some natural operational cycles where we have less capacity to do project work, but we have to plan for that. The other thing to keep in mind is that if you are changing rules or regulations, that's sort of a natural break, particularly if it's related to things around continuing competency. You did that when you implemented new continuing competence categories for non-clinical. You timed it so it went into effect at the beginning of another licensing cycle instead of a mid-cycle. So that's why you see some bolding there. The other way that you could look at it is the odd years are always the long policy sessions legislatively. And maybe that's why I'm trying to block it out without bold text. But that's another pattern that you're going to have. The other pattern to keep in mind is that state governments work on fiscal years, not calendar years. So when I say 2025, I kind of mean July 1, 2025 through June 30, 2027. And that pattern repeats through that. That's relevant because your budgets are set on that biennium pattern. So when you're mapping out your strategic plan, you probably won't think about bienniums, but then when you're operationalizing the direction that you want to go, we will have to map things into specific biennia. The other piece, when we talked about the impact of House Bill 3824 that could have on the significant amount of policy and rulemaking you would need to do relative to the bill, that takes you 3 years in, with assuming that we can do a July 1st, 2027. And then you have a renewal that goes into 2028. So in the things that you're planning and when you're mapping those out, there's a significant body of work that we may have or may not, but we may have and that's part of what's driving a 10-year look instead of a 5-year work. Because if we were only looking out 5 years, 3 years is most of that. And then, what next? The other reason that's up there is in our current, the SWAT that you did actually last September, and in our succession plan, is that you do have a staff that either based just purely on age or years of service, you have a significant percentage of your staff that's at least eligible for retirement in this timeframe. And kind of in the middle. So that continuity of operations, right, organizational continuity is something else that makes sense to look out even further than that significant change will happen. But something else that even starting now, we need to make sure that the organization is well positioned no matter what changes happen when. And then I would also probably lay out, and we'll get to that, but the last piece that I think about is the current, if you think about earlier in the meeting when I was talking about the trends about a 1% sort of increase in 1.3% in license counts, and you compare it to the percentage increase of our expenses operationally, which are closer to 11 to 17%, depending on the year. That's not a sustainable model. And so looking out 10 years, how is that going to work? And technology as the last piece. And from that, I know we often talk about, and this is on one of your future topics, but the impact of artificial intelligence on regulation, on state government, the expectations and the capabilities. And I would anticipate significant change in the next 5 years. So with that framing, yeah, I get to turn the easy part over to you. And by easy, I mean hard. Sarah, can you go to the next slide? Now what we have for you is a work session. This is for you to have conversation, for staff to take notes. This is the beginning of your next evolution of your planning process. So you can reference the current strategic plan. I intentionally didn't start us from that document because I wanted you to be able to take kind of a fresh, oriented on the frameworks, but to take a fresh look with what you've been experiencing in conversations. And I have 3 questions for you to talk about today to inform the next part of the process. The first one is a discussion on what trends are you seeing, or what do you have questions about? This is sort of the research and the reference portion of it. I want to make sure that there's time to ask questions about what we already know. I just laid out some of that as far as work efforts and what we're anticipating, at least in the near term. And then the last one, how do you want to engage community members in this process? In the past, it's been in the form of community strategic planning events. You send out the invitation to everyone, invite them to participate with you in a workshop. There are also surveys, different mechanisms that you can do to make sure that there is as broad a community engagement and participation in your process. So some time to think about, what approach do you want to take? Or what ideas do you have? So those are your 3 main questions for discussion today. And we will take notes. We can leave them on the screen. So we can start with the first one.
Ready? Oh, okay. Tim?
Say the trend we're seeing is a work place shortage,
Excuse me.
a workforce shortage, for the need, and the creative ways of trying to meet that need, whether it's through extenders or through application of electronic versions of physical therapy, to still try to fill the need of the population we have.
Well, on that, I think what worked was what we already did in terms of that revision around PTA supervision. Like, I think that helped some with that, but that wasn't what I was going to say. And I was skipping to the last one because I'm jumping around, but we've been talking about it since I've been a board member, but about like having meetings other places in the state. Like, as I know, Sandra and I travel, and just being able to have meetings in other places to engage community members. It still feels like, Michael and I were just talking, like something that happens really removed from where I practice. And if I hadn't had this opportunity, I wouldn't really know. So.
Tim?
I can add another one is, I think nationally there's a push to expand the practice in the types of services physical therapy therapists provide. And we've seen that, as an example with HB 24.
The strategic planning have, but environments, I know, is always something. Am I on? Oh.
Yeah, you just gotta really talk
Okay.
about
You know, the way the requirements we have now, is that really helping keep people, you know, up to date on?
So the continuing competence.
continue-
Okay.
Yeah.
And I think somewhat on that, maybe we have that emphasis on pain, but so many of what we see come before the board, again, has to do with boundaries and that where it seems like oftentimes promoting these classes for boundaries and why isn't, it's not about protecting people against not having their pain managed, but some of these other issues that maybe with competent practice and protecting the public, there's more of an outreach or emphasis on that.
Yeah, I agree with that. The other thing that bothers me that is this national trend and maybe even global trend about not respecting boundaries and the enforcement of fractions, I guess. And then, I think you mentioned that it was kind of a big topic, deregulation. It's kind of been a topic since I've been on the board, the push for deregulation, but there's like really a surge on that in the leadership of this country right now. And I wonder how that impacts protecting the public. Did that make sense?
Absolutely.
I would also add, I'm genuinely concerned for the state for post-acute or long-term care for patients and the
Oh,
lack
yeah.
of physical therapists in that area. This is a really high need with a very severe shortage.
For all services, actually, including physical therapy. Yeah.
Correct. Yeah, I mean, not just rehab, but
Yeah.
nursing and yeah.
Thoughts about how we want to engage community members?
Can I go back to number one,
Sure, you
even though
can.
they're not numbered?
Yes.
I do think the animal physical therapy world is trending nationally, and it could definitely potentially be something in the next 10 years, since we're looking at 10 years.
Michael?
I think on that, one of the pieces that might be helpful, because it makes me think about, if you look at population data and you look at Oregon, typically it's the on Multnomah, Washington counties that have negative net migration. And those also typically are the counties that have the fewest practitioners in all disciplines. And so that seems to be when you have counties that are aging older and do not have the younger population, but you have the least amount of available professionals, and professionals are also aging out of the workforce. It seems that it creates an undue burden on rural counties. So I think it would be interesting as part of your process to bring in speakers on population dynamics and projections in Oregon, because I think that could inform some of your conversations, if that's of interest.
I could add a little bit more to what Michael said is, so physical therapy practices outside of the hospital system that are independent there, the reimbursement for Medicare has actually significantly dropped multiple years in a row, while our expenses have significantly increased. And so if you think about rural access, where some of those rural areas you have an aging population, the viability of a practice outside of a hospital system to supply the needs of those communities is going to be significantly compromised. And you're now seeing, small rural hospitals that are not able to be viable under their circumstances to provide care because of that change in reimbursement.
And if you don't have the private practice capacity, it moves patients into the hospital system that's already over capacity.
Yeah, yeah, kind of a cycle.
The real uplifting conversation.
Yeah.
I was also thinking about how that relationship between like the cost of education for PT school
Yeah.
and earning capacity is diminishing all the time. So that feeds into our workforce deficit, and then how that also contributes to all that moral injury, burnout, and those situations that come to us here on the board, like Susan was saying. One other thing not related was what we're talking about in the clinic is using AI for documentation to minimize like the time that we as clinicians spend documenting. But I think we're going to run into some problems that we can't even foresee at the moment with that. We're trying out some software, but it's not perfect.
I do have a anecdote about that if the board's interested. AI document. A situation recently in the state of Louisiana. They had a situation where a clinician was using a AI-based transcription tool, which you see many providers doing. And they met with a patient and gave a very cursory, do you mind if I record this to help with note taking? And the patient happened to be a data scientist, and so very familiar with how data collection works, but had the treatment and began to ask more questions about the specific company that was being used. What neither the clinician or the patient realized during the entire treatment session, small rural community in Louisiana, they had known each other, had been going to treatment for a long time. So a lot more detail than you might have in a different kind of encounter. The particular provider of this software, if you look into their terms of service, the full recording, not just the transcription, was transferred to the software company's servers with full personal health information, unredacted. As part of the transcription service, they have humans in the process to verify the machine's transcription that were also therefore reviewing both the transcribed text and referring back to the original audio of the treatment session, also unknown to the practitioner at the time. And so the also the piece of it is that it was the professional's personal device, because the clinic that he worked for didn't have the technology themselves to do it. So it was an app that was downloaded on a personal phone that was being transferring these things out. The clinician felt or believed that it was being transferred to the clinic's servers and not going anywhere else. When the data scientist requested the removal of all of their information, they ran into the terms of the product that required the archiving of the information indefinitely. And part of that is because they, of course, are further training the AI tool. And so they use those recordings and the rating of the humans who are comparing the transcriptions. And so even though they were able to have their information removed from the primary server, the company would not guarantee that it would ever remove from the archive that unredacted personal health information. Louisiana does not have any regulations that specifically address any of this. And so they're exploring this kind of situation. But to your point, I think, clinical use and application of the tools, it opens up things that I think go far beyond what our licensees might even think to ask on that, or what folks are consenting to when they say, do I mind if you record me? Mind if this company has your recording for the rest of time? So it's a great question. Right. And I think another piece of this is as technology advances, the clinic agreed to the terms of conditions, right? And the clinic dictates what tools the practitioners use, who may have no line of sight or understanding. But you hold the individual accountable, the individual licensee. And so how does that work?
On now?
Yep.
Along the lines with, Michelle brought up Louisiana, I've been in contact quite a bit with Charlotte, who's the director at the Louisiana board, about just rural PT in general. We've been talking a lot about the challenges of rural PT with boundaries, and everybody knows each other, and how, if you're not treating your friends, you have no patients, and if you aren't treating your patients, you have no friends, right? So kind of, we've been going back and forth a little bit about education for practitioners, kind of a thing, as far as boundaries goes, because it's really hard when you know everybody and you're going to see them in the grocery store and you're going to see them everywhere you go, and maybe your doctor is your patient, that kind of thing. So I think that's been something it's kind of on my radar a lot, to think about. And while I'm talking about Charlotte, we also had a conversation I think is real interesting when when we have somebody who's been disciplined by the board and they are either on probation or suspension or something, they do an exit interview at the end to see what their perception of the whole experience with the board was, which I think is really neat. And I would love to look into it. I asked Charlotte to send me how they do that, because they talk about trauma, like the trauma of going through this investigation, whether you did something bad or not. Like, you have to go through this, and how long does it take, and how informed are you, and what the board's doing, and the whole, what I'm doing, and the whole process along the way. I thought that was a really interesting concept to share the public too, right? And how was it for them going through what they had? And, it's one thing, the Boundaries Committee is still working on doing videos of real people who have been through disciplinary actions with the board, and the whole process along the way.
Happy to share more stuff about AI. Um, One of the things that there's a trend with the scribing is tech companies are using scribing to collect data. They're mining data to create either improved healthcare or actually creating the next, physical therapy 2.0 that maybe is in personal off, but more of electronic version of physical therapy. A lot of entry in reason why they're doing that. And some organizations will have, say, a traditional product that's very cheap to get them in the door to have, other buyers or other information. And that's oftentimes thought of the IT world's ability driving to get that data for their AI model.
Well, I think that's a really good point about the record, the individual therapist not knowing what happens. Because I get a lot of calls about our retention, you have to retain your records for 7 years as in our rules. Well, if you leave that employer, you don't know what they do with the records. You don't know if they keep the records. You left, you're not going to take all those electronic records with you. You can't do that. So, I feel like a lot of licensees don't know what happens after I write my chart note, or, even the billing, what happens after I write it out? It goes to a different person who's dealing with the billing. It's not really the PT that's dealing with it. So I think that's a real challenge too, especially as we start getting more and more into different kinds of documentation systems that people might not know. Well, I just have this much space to write what I'm writing and I don't have more space. They don't give me more space. Like I can only put in 50 characters. Well, what if I need to write more? Or after I, hit the send button, then where does it go? Just like you said, that's a really great example of the clinician being responsible, but not really knowing what happens past them.
That makes me think of when we think back to the Rule Advisory Committee that was just informing the changes in Division 40 on documentation standards. That what's really fascinating is that a lot, particularly around documentation and paperwork, you can tell that the rules were written at a time before technology, before electronic record systems, where the assumption is right back with my yellow pad, right, and a file folder, and that was the patient record, and so much has changed since then. And what became super clear because a phenomenal Rule Advisory Committee that had representation from all over the state, but from all different care settings. And it was fascinating to see the differences if you're right in the hospital setting versus the school setting versus the private practice, and how sometimes just and that maybe there are other instances where it would make sense to have care setting based variants in some of your regulations, perhaps because the criteria are different. And, kind of to records retention, maybe it makes sense to have 7 years if it's private practice and you own the records. But when you're a contract PT in a hospital and you have no access at the moment, what about those patients and those patients' records and access to that? And how does that work?
I also get a lot of questions about, I'm closing my clinic. I got a question like this week. I'm closing my clinic. What do I do with my records? Who do I give them to? Who's responsible for them? What happens now? Oh no.
Right.
I don't know.
No. Recording. Turn it on for the recording.
Cream.
Turn them all up to 11. No, but, I would encourage to not limit, because these conversations, when you're thinking about patient care in Oregon, this may very well be solutions outside of your direct authority, but you can engage in the conversation. So I definitely count it, and then maybe it's something that becomes something that you partner to try to address or raise legislatively as a gap that needs to be filled.
I also think thinking about AI, a big trend, Gayla can probably speak to this, is how many people are being employed by big, I don't even know what you call these companies, like digital health companies that are treating patients with telemedicine, but they are like, that's solely what they do. And they get compact privileges all over the country, and they're just dabbling here and there. And like, can you really provide the quality of care via telehealth that you could do in person? When everything, I mean, I've tried one of these things, and there's like a little thing on my iPad that's telling me to do this and that and whatever. And it's like, great job. I'm like, no, I didn't do a great job. I actually almost fell down. And, so personally, I think about that a lot. It's like, well, what's being delivered, and is it the same quality of care that people would get either in person, or what the initial thought of telehealth was? Right? Thought of telehealth was a rural person who needs to access the care and they can't get there, versus these huge companies that are just all over the country, and that's how mainly by PTAs.
Well, but I think with that, I mean, we talked about it maybe a year ago, like the advertising that it's an AI PT, because that's not a PT that's even on your iPad at that point. And the way they advertise for come work for us, and all you have to do is this eval. And then your entire treatment plan is carried out by AI. And it's a little, who's responsible for that at the end? Like, that's how they advertise recruitment. Like, you don't even have to do treatments. It's just evals, evals, evals. And then you don't know who carries out your treatment plan.
And,
That-
and there's also the communication piece of it. Like, I would get text messages, this is your PT, blah, blah, blah. I'm like, is this really a PT, or is this just some Autobot that's sending me a text? I don't know. And I think that's with a lot of patients are like, who's this from? Is this really my PT Tim sending me a text, or did some auto thing gets, whenever I have those things, I'm always, is there a real person in there? Or is it just automatically spitting out based on what the information I give back? Something gets automatically spit out back to me.
Do we have any protections in place for like how the term PT can be used in that setting, or has that not been addressed because the digital stuff wasn't there yet?
Yes and no. There's title protection in two places for the use of the term doctor, and how you can use that and how it relates to DPT. And then there is some language related to PT, physiotherapy, physical therapy. Um, but what becomes unclear is that that's tied to individual practice. What is hugely vague is if you have a software product, particularly one that you don't even know it has a presence or a person who's in the state, then there's little to no authority to get to that. It becomes very gray. But there are some pieces in the association's bill 3824 that are trying to strengthen or at least make more concrete some of those sections. There is also, could be a consideration, the Nursing Association, and I didn't check on it recently to see how it's doing in second chamber, but the bill is very simple. It defines you can only use the term nurse if you're a human being. So Yeah, both. And then there's also an element where it gets into the definition of the practice or unlicensed practice of physical therapy. So title protection, term protection, and then practice scope definitions. And some of that can be when you have statutory language that says only a person, can offer, or if a person offers to do this, then they have to have a license. So then the question is, well, it's not a person doing it. So do you have authority over them? Yes, maybe, no, maybe. Yep. Yeah, but when the underlying regulation is defined in terms of a person, then that limits the term protection as well, unless you don't have that. And we're kind of getting into legal interpretation areas, but that's part of why I think you have an explosion of some of those organizations, particularly when they begin to frame as digital health, right? Or wellness, right? Uh, and nationally, so many of the scopes of practice are based on this assumption that you have a person that's interacting with another person, usually in person. Um, and the technology allows something that exceeds that meaning that the law was based on.
Just kind of going off of that a little bit, I do think just as being like a newer grad and just the cost of living and how much PTs are being paid, there is also kind of this drive towards doing jobs like that where maybe you don't feel the best, but you're already working your full-time job and you have to do this on the side to really feel like you can pay off your loans and do those things. Like I have 2 jobs, and I just think it drives people toward maybe things they wouldn't normally like ethically feel comfortable doing. And I do think that's going to be a trend that we see like increasing as the interest rates on loans go up.
I have a question. Since I'm not a part of the field, salary wise, what does the average physical therapist makes on average?
The graduate rate would probably be somewhere between 85 and 90 starting thousand
For PT.
for PT,
PTA?
top of my head. I mean,
Google says 65. 65.5.
It does definitely vary a lot. Like when I started, I was making 62 and I still haven't quite like hit the averages. So it is, and I think when you're trying to avoid burnout, like I definitely work a job where I don't make quite as much because I feel like it's more sustainable. So I do think that is also tricky.
if you go to the Oregon Labor and Industry Board website, and there's a salary based on our counties and regions, and it gives you the bottom 10%, top 10%, and it lists the ranges of that.
One thing I think of too with salaries and the retention and things is, and I don't know if it's still like this because I haven't practiced in a while, but like sign-on bonuses to go work somewhere, you get offered some big sign-on bonus to go work in wherever it is. And then you get there and you're like, ugh, I don't want to be here. This is not the place I want to be, but I just got a big $10,000 sign-on bonus to move to this community and be here. And I had to commit this much amount of time to be at this job. And so now I'm sort of stuck here. Or, that might not be the place that I really want to be, but they're offering me this bonus or to go stay there. And then that's a dilemma, moral dilemma for people too. It's like, but I don't want to have to pay back that money, or I need that financial benefit of being at this job. And I really loved your point about people taking multiple jobs, because I think that is very hard. People start getting to the point where it's like, well, I can't do all this. I've taken on all these jobs and I can't do all this. So you start skimming. Quality goes down because you're just trying to do it all. But you need to.
And anecdotally, it's not just the sign-on bonus. It could be a non-compete where the idea is like, I have to stay in this position or else I have to move. A close friend of mine is licensed in Oregon, but had to move to Boise because she could no longer sign a contract in the Portland area because of the non-compete in her contract with her employer. Yeah. That's not just PTs, of course.
One other piece that I would propose is when looking at concepts of informed consent and consent to treat, that process from a patient's perspective, that experience can be very different and can happen completely separate from the physical therapist or PTA, in that for folks that are like maybe part of a major insurance provider, particularly the HMO forms of insurance providers, you go to a check-in, you get electronic signature pad about this big with no actual document assigned to it, and they ask you to sign consent for treatment, which has all of the clauses about informed consent. And that's before you go 3 floors to the physical therapy department to meet somebody who also maybe hasn't seen that. So if we think about kind of the care settings and these topics in that context, what does that mean then for your expectation of the physical therapist with regard to informed consent and what they should do, and how that's different than what the healthcare system thinks of those words mean, and how to say it differently, and how to make sure that that's part of the treatment interaction in that kind of care setting.
And the whole thing's been really interesting because he's had a lot of physical therapy, of course, but he got his surgery in Bend, and there used to be, when we first moved there about 14 years ago, there were 2 really big orthopedic offices. I mean, Bend's really into orthopedists because of the outdoor nature of things. So they've been around for 20, 30 years. Well, they're both now dissolved into the St. Charles health system. So there's it's a monopoly now. I mean, it's really hard to be independent for physicians, for sure. There's a few other that they're not standalone, but they might not have the big monopoly, but it's almost all St. Charles now. So the one that my husband was going to, he's been there before, but the day before his surgery, I think, or the week before his surgery, St. Charles took over. And so the first thing that happened is on the first Monday, they switched the phones and you could not reach his office, anybody in that office by phone. The phones were completely down. But it's all that consent for treatment, and you sign here and then you really don't know. And one interesting thing was, so we have our physical therapist, which is the standalone in our community. But part of the surgery thing was you had to see the physical therapist before, and then you saw them in the recovery room. And so we consent to it, but we didn't really get that would be a separate bill. That's been one of our only out-of-pocket bills, and it was hundreds of dollars for this very short little thing that was helpful, but it wasn't really necessary. That we didn't really feel like we didn't really consent to. So just even like the billing portion is bizarre, and mixed up, much less what you're agreeing to.
I don't want to stop the topics because this certainly isn't your last opportunity to address that. I do want to shift to have us be sure to have some time to talk a little bit about the engagement process, and kind of your thoughts on that. And to Susan's point, don't feel that you need to limit it to just community engagement in the strategic planning process, but feel free to keep it open to community engagement in your process ongoing for board meetings. But what do you want to see? How do you want to bring in input? I can already see some places where bringing in some other speakers from other organizations or subject matter experts would be helpful for the first part of what you've talked about. So one option could be opening up those sessions, almost advertising them as a special session, and invite the larger community to come in and hear those sessions, where they might not be as drawn to just your regular board meeting agenda, but if they know that that's a specific topic that's been advertised, that could be one approach. But what else do you want to see for us to do to engage the community?
Pre-COVID, pre-COVID, we went to Pacific and had our public board meeting there. And I thought that was a really neat experience. And I think that was our intention, was to continue to go to a college once a year or something and have our meeting there to involve the students in the process. And I thought that was a great idea. So if there's about how, I know there's a cost involved for traveling and all of that kind of thing, but
I know it was in the slide. Forget what part of the agenda when Michelle showed like the things that the staff does. But we do go out, Gayla and myself go out to all the students, third year PT students and second year PTA students. And we also go to the first year PT students and do different lectures each time. And I've been kind of, we used to just talk about the exam and applying for the exam, but I've been talking a lot more about consent and boundaries and things like that with students so I can get to them before they get out in the field. So we do that, but I agree. I think having the whole board there help. And we really do try to do them. Like this summer, I'm going to OSU in Bend, which is an expense for, to send me out there. But I thought it was really, and I did say, well, can I meet with both classes on the same time so I don't have to take 2 trips to Bend? And they made that happen because they thought it was so valuable for me to be there in person. They're like, whatever we need to do to have both classes here at the same time, separate times, but same 2-day period, that way I can be there in person. Talked with them yesterday, it's a little bit of a drive, but Gayla and I go out there to meet with them. So to make that effort to meet with the programs. Down in Klamath Falls, I presented virtually for his class because there's only 8 kids, 8 students there. But I think that's great. I also have been thinking, I've done so many national presentations on boundaries and consent and things, like maybe we do those here, in the state. A lot of national people are learning this stuff, but how do we, and I know that APTA, I actually reached out to Jeremy Hilliard from APTA because some of those meetings are, they're attended by a very small population of people who are really invested in the profession. But I don't know that those are the people we need to get to, right? I think this other licensees we need to get to than that, those 50 people that show up at the APTA meeting. So, maybe we look at education or free CE or, mandatory, somebody said mandatory CE or, whatever that might be about boundaries and stuff around the state.
I have Dwight and then Mariah. I go Mariah and then
Go,
Dwight.
go Mariah, I remember what.
Mariah.
I should say that free CEUs are so attractive, and I think it's a great way to just add a little pizzazz. Like, I really didn't know what the board did before I started learning and through the application process. And I think that's how a lot of licensees are. And, the website's very clear, but when I think about all of these like emails that I get from, I don't know, just different organizations that I'm a part of, it's like, it's got a bit more flashy headlines that like draw your attention of like, learn more about boundaries and how to protect yourself. Cause I do think people are scared of getting sued and scared of things happening, but then they just don't know what to do about it and they just get freaked out versus we could promote something like that while also teaching people about the board. I think that's such a good opportunity. Yeah.
So my question was about community. Speaking of, you're talking about people in the business, excuse me, in the practice and general people and just general anybody or?
I am so glad you asked that question because that's part of the discussion that you all should be defining. Generally speaking, on the slide, it's meant every possible community, whatever that engagement. So whether it's existing licensees, folks in the business, pre-service candidates, even before they go into the educational programs, the general public, the tribes, right? Probably the arguably employers, the healthcare system, other practitioners, as broad definition, legislators, right? Open-ended.
I mean, thinking of employers too, when we talk about shortages, like, we talk about how many licensees we have and how delayed is the workforce data and to know how many openings there are. And is there, are we a barrier to that or how we can, support those bigger entities, not support, but be a resource to some of those entities. And I really, in terms of community, just want to back up what Sherry was saying about to have that information from the community of those people who have interacted with us, either as respondents or witnesses or something to understand how our engagement is with them.
That's a great point about employers too, because I think it was not last summer, summer before, they brought in myself and someone from the speech board and someone from the OT board to speak at a conference for school administrators so that they can understand what do the PTs, that some of them had no clue what PT, OT, and speech actually do in the schools and what should they be doing, and our rules, no clue. So that was great. I've been thinking about that. Like, well, I wonder if they have that conference every year to bring us back out there. But even, there's a lot of employers. I mean, how many times have we seen someone starts working and they didn't get their license yet, right? And people don't realize, oh, they need to do that too. So to get out there to different employers to really understand like what's the scope, because we also get all those questions. My employer's asking me to do this, help. I'm not allowed to do this, or I don't want to do this. I mean, those two different things, but the things they're not allowed to do that they're being asked to do that their employers just don't understand the rules or what the boards even, because especially because it's so different, right? PTOT and speech, we have slightly different rules.
Thinking
Statutes.
thinking about what Sherry was saying about, going out to the schools and how much they appreciate that. And then with what Mariah was saying about new grads, we I feel like we miss sometimes that only 20% of PTs in Oregon were educated in Oregon. And so we're thinking we're doing all this great outreach, and we are, but we're doing all this great outreach for 20%. And so figuring out a way to capture that new to Oregon licensee, I think that's a community that we don't necessarily think about because they are a little bit outside of our classical categorization. So thinking about, what can we do for the person who's been licensed in Oregon under a year?
I don't have an answer to that question.
Okay.
But I was thinking, like, we're talking about how to kind of get more maybe transparency or get, I think a lot of people view regulatory boards as being punitive. And so not to say that we need to change the way that the public perceives us, but maybe it's an opportunity. Most people I know, and this it maybe speaks to the kind of people I know, most people I know get their news from social media, and I know that has like some other implications, and that's a whole job in and of itself. But like, if we were to do like some kind of webinar series or something, that would be a place that you could reach lots of folks. And then, you'd have to build up a following. I don't know how to do that, but like where licensees could see those updates on like their social media feeds and receive that information, like kind of a trickle effect rather than like them having to go to our website to see it.
I mean, I think that our YouTube does have about 7 subscribers, so we're pretty active on social media.
Yeah. I think what those are some great points, Hoku. It all of this discussion about engagement, it makes me think about the difference between impact and value, because I think you as the regulatory body definitely have an impact on licensees and on the public in the decision that you makes, but value, the perceived value, is different, right? And I think a lot of licensees don't necessarily see value simply in you existing and passing regulations. So maybe what I'm hearing is sort of this framing out of not just necessarily moving the board meetings around the state to engage it in the way the board meetings are now, but really talking about what do the different community members value and how can you offer that to them, whether it's social media posts or webinars or out in the schools. And that's kind of what I'm hearing you guys talking about, how to do something that has meaning for them.
I was gonna say I'm probably older, but I miss like it still is like I miss that little blue thing coming in my mail every month that was from the Oregon PT board, and it was like, where did it go? And I don't go on social media, and I miss my mailbox having that. So it's different depending on your
Newsletter?
Yeah.
Oh, okay.
The blue newsletter. It was blue, and it came and you went right to the page that said, do I know any of these people in here? And very gossipy, but it was like that held a lot of value to me. That's how I read it. And that it doesn't mean that the board doesn't, and I get there's an expense and all of that with that, but it's hard. Like when I hear you say social media and I think, oh, I'm going to have to get on Instagram or something, that it's just a different who our community is. I think, like Dwight said, to define our community and under this very inclusive umbrella is, it would be
Well, and
hard.
that's a great point, because if you think of community as like patients, even the older population, like there's no way. I mean, my mom gets telehealth. If I'm not there at every single appointment, she cannot get on. It's been 2.5 years. She still cannot log on the once a month appointment with this doctor. If I'm not walking her through it, 2.5 years later, she still can't figure it out. how do you get on? What button do you hit? And then you got to do all this pre-stuff before the meeting. She can't even do that part. And I have noticed, at least in me communicating and the board communicating with complainants and with licensees, email these days, just there's so much junk email that stuff gets so lost in email. Like there's a lot of times I just have to send someone a text to say, hey, I sent you an email, and then they'll find it. But I do feel like email these days are even getting harder and harder because people just don't look at it, or it gets lost in it. And plus, like, I got a really important email today, and it got caught in my quarantine. Like, well, how did that one get in the quarantine? Like, I should have gotten that email. So I think thinking of different ways to communicate. I know like California board is real big into social media. They do Instagram and Facebook, but then we have to make sure that we're monitoring that and how we answering those questions. And I think that's a big,
Yeah, I
big
think they
thing.
have a staff of 14.
They have, right. They have a staff who just does that. Right. Cause that's, someone posts a question and then you either don't answer it or answer it wrong.
That can be worse.
That's worse.
Yeah.
Right.
Michael.
Yeah, just on that topic of staff, like, so with the growth, if we project a growth in licensees and with the complaints that are happening, we need to Sherry. I mean, I think just really thinking about the staff size in relation to not just the denominator, but also I think complaints are more, so.
Yeah, I think we're being really open-ended right now. All of this does need to be brought back down to a understanding of constraints, so that you can see kind of what availability or capacity would be, and operationally what it costs, and that we can kind of map out if we were to expand into this area, here's what we anticipate that budget impact would be. And then you can make those informed decisions about how to approach that. Yeah, it's a great point. I do want to, we're kind of at the time that we'd anticipated for this topic. It's only the beginning. We have, a nice yellow pad and recording of all of your thought process on these two topics that we will take as staff, flesh out to be able to bring back to you with not just the list of what you discussed, but kind of translated into some of the implied next steps or potential speakers or some of that, to be able to bring that back to you in July so that you can talk about, in particular, the September meeting, which is also currently scheduled to be an in-person meeting here, and what you might want to do as far as community engagement there. Any kind of final thoughts to throw out before we bring this discussion to an end today? Yeah, then, Madam Chair, we can executive session. Start over.
The time is 12 p.m. and the Oregon Board of Physical Therapy will now convene into executive session as authorized by ORS 192.6602 f L. In executive session, the board will consider information obtained as part of an investigation into the conduct of licensees or applicants, consider investigatory information and reports under ORS 676.165, consider other information or records exempt from public inspection, consider advice from the board's legal counsel, and to consult with legal counsel on current litigation. No decision may be made in executive session. The board will reconvene into public session at the conclusion of executive session, which is expected to last several hours. Any members of the public in the physical or virtual waiting rooms at this time will be brought back into the meeting room before the board reconvenes with public session. The Time is 4:11 PM and the Oregon Board of Physical Therapy is resuming public session.
Madam Chair, the next item is board motions as a result of executive session.
Madam Chair, in case numbers PT 886-12/24 and PT 887-12/24, I move to find violations of ORS 688.140, Section 2, little a, OAR 848-040-0105, Section 5, OAR 848-040-0170, Section 1, and OAR 848-045-0020, Section 2, little I, little L, little p, big A. I move to offer a settlement agreement with a $4,000 civil penalty with $3,000 stayed for 1 year pending successful completion of a board-approved boundaries course and a board-approved documentation course, and to modify their practice with the following. 1, offer chaperone if requested, only provide services when a chaperone is present, and 2, offer a physical barrier when skin-to-skin contact is required.
Second.
Motion's been first and seconded. Roll call vote. Timothy,
Aye.
Aaron,
Aye.
Mariah,
Aye.
Sandra,
Aye.
Hoku,
Aye.
Susan,
Aye.
Erica,
Aye.
Dwight.
Aye.
Madam Chair, the motion carries unanimously.
Madam Chair, in case number PT 839-12/23, I move to offer a settlement agreement of 6 months of probation and a $5,000 civil penalty with $2,500 stayed pending successful completion of a professional boundaries course. During the probationary period, the licensee must provide any employer with a copy of the stipulated agreement with evidence of this provided to the board and is restricted to working with another licensed healthcare provider present in the building when providing PT services.
Second.
The motion's been first and seconded. Roll call vote. Timothy,
Aye.
Aaron,
Aye.
Mariah,
Aye.
Sandra,
Aye.
Hoku,
Aye.
Susan,
Aye.
Erica,
Aye.
Dwight.
Aye.
Madam Chair, the motion carries unanimously.
Madam Chair, in case number PT 885-01/25, I move to accept the settlement offer proposed by the applicant.
Second.
Motion's been first and seconded. Roll call vote. Timothy,
Aye.
Aaron,
Aye.
Mariah,
Aye.
Sandra,
Aye.
Hoku,
Aye.
Susan,
Aye.
Erica,
Aye.
Dwight.
Aye.
Madam Chair, the motion carries unanimously.
Madam Chair, I move to ratify the administrative closure of cases PT 896-03/25, PT 900-03/25, and PT 901-04/25.
Second.
Motion's been first and seconded. Roll call vote. Timothy,
Aye.
Aaron,
Aye.
Mariah,
Aye.
Sandra,
Aye.
Hoku,
Aye.
Susan,
Aye.
Erica,
Aye.
Dwight.
Aye.
Madam Chair, the motion carries unanimously.
Madam Chair, there are no more motions.
Okay, thank you, Susan. The time is 4:16 PM and the Oregon Board of Physical Therapy is adjourned.